Hi there, this is Kaushik Ranchod from the Ranchod Law Group. Welcome to our immigration show. Today, we're going to be talking about I601A waivers, and we are going to deep dive into some case studies. I want you to be familiar about what works. By looking at what works, maybe some of it will resonate with you. So if you haven't already, smash that like button. Let's dive right in. So we're going to be talking about two case studies, one from Mexico, one from a client from South America. Very interesting, so you'll want to stay tuned. Post your comments below if you have any questions or if you have any suggestions for videos, because I do try to respond to your comments, and I also like to get your feedback as well. So the first client is a client who is from Mexico. They entered it in the early 2000s. Now the client is contributing to the United States as a carpenter. And how does he qualify? So really what's really important to note is in order to qualify, you have to have a US citizen qualifying relative. So what does that mean? Well, to just basically qualify, to be able to apply for this, you need to have a US citizen or lawful permanent resident spouse, or a U.S. citizen or lawful permanent resident parent. Kids in and of themselves don't qualify. Now, I know I got one of my comments that said, well, you know, the kids suffer too, family members suffer too. I 100% agree with you. I'm here to be the communicator of what the law states. So yes, kids do suffer, absolutely. Yes, other family members suffer. And I like to incorporate that into my arguments about how the other family members are going to suffer. But because of what the law states, we can't file I601A waiver even if your child's suffering, if you don't have any other qualifying relatives. So yes, that sucks. That's what it is. However, we could make an argument to say, well, you have a U.S. citizen spouse, like in this situation, they have a U.S. citizen spouse, this case study, they have a U.S. citizen teenage daughter, and that daughter would also suffer. So yes, we're going to bring that into the argument when we're explaining why this qualifies for extreme hardship, but we're able to do that because of the qualifying relative, because of the fact that there is the U.S. citizen spouse. I hope that makes some sense to you, because I know this is confusing, and I'm here to make it hopefully a little bit less confusing for you. Now, the other part to this is that we argued financial hardship, we argued career hardship, because the U.S. citizen spouse is taking a course, a technical course. So they're bettering themselves by taking this course. Now, they wouldn't be able to do that if she was separated. So that's how we were able to argue financial hardship. Another argument that we made is that the client's wife also gets medical coverage through the state. Now, if she had to go and live in Mexico, she wouldn't get her office visits paid for, her medical coverage paid for, like she does here in the United States, where she's getting that covered through the state. So that was another argument that we made. Another factor that we argued was that the U.S. citizen spouse was also taking care of or helping with her parents' medical issues. Now, if she had to relocate, she wouldn't be able to help her parents if she had to leave the United States. So as you can see here, that we weren't using the parents as a direct qualifying relative, but we were able to make an argument about the hardship nevertheless. And then finally, we also argued that the client's spouse was really worried about and getting anxiety about her husband being deported. And so that was causing her anxiety. So that was another argument that we made as well. Now, generally, you can't just say, oh, well, the client's having anxiety. You have to back that up with a psychological evaluation. If you're seeing a psychotherapist, that's helpful to include as well. So that is case study number one. Let's move on to case study number two. Now, in case study number two, clients from South America, and the client fled from South America, went to Mexico, and then crossed without a visa into the United States. So in this situation, the client qualified because of the client's spouse, and she has an eating disorder. So that was a factor of extreme hardship because that eating disorder was just not an eating disorder, it was a coping mechanism in order to deal with the mental health issues that she was facing. So since the eating disorder was not about food, it was about emotional hardship, that's what we talked about, how that would physically affect her, how that would emotionally affect her, that this eating disorder would be exacerbated through the separation. And that was a factor of extreme hardship that we were able to successfully argue. Now, she also received healthcare through Covered California, so similar to the other case, she would lose that healthcare coverage if she had to leave. And then we also argued that they should receive a favorable exercise of discretion because they do volunteer work as well, so that was a positive factor in their favor as well. So we used all of these arguments in that case to get a hardship waiver. So you can see there's some similarities here of financial hardship, emotional hardship. Now they weren't the exact same facts patterns, but they still had those different types of emotional hardship in different ways. So your situation might be similar to that too. You might have emotional hardship, and maybe not the same as in these cases, but in your own form of emotional hardship. So I invite you to contact us, post a comment below, and I want to thank you so much for connecting with us, and thank you and have an amazing day. Bye for now.